Guys, we about to go?
Good morning, everyone. Are you awake? Great. We have our next set of speakers this morning. Timothy Greene and Kenneth Chu represent company Oric, Harrington, and Sutcliffe LLP. It's an international law firm that was founded in San Francisco in 1863. Oldest continuous labor law firm in San Francisco. They have 25 offices around the world. Do you have any in Kazakhstan?
No, we don't. Just opened one in Africa, though.
You heard them.
This is good.
Well, Africa is closer, I guess, to Kazakhstan. Yeah, but Oric is well known for technological companies, and our speakers both have a law degree from University of Chicago and specialized in copyright law, intellectual property, and they're going to tell us about IP and its commercial potential.
Thank you. So can everybody hear me and this isn't like too loud? Blowing it? Good? Okay, cool. So as as our introducer said, I'm a technology transactions lawyer at Oric. Typically we work with small early stage companies. They basically run the gamut from, suppliers of consumer products all the way out to, your kind of standard like Instagram, Facebook style companies, right? So what we're basically going to do here is we're going to kind of give you a kind of high-level rundown of the various types of IP that you can have in the United States. They might differ a little bit from international. And then we're also going to run through some of the pitfalls that you might run into when you're dealing with commercial contracts of various types, including IP concerns, but not specifically limited IP concerns. So basically, what kind of transactions involve IP? If you look at our list right here, it is essentially any type of deal that you could ever do or ever work on. Basically, you can think of these as different labels for different types of deals you might want to do, right? So a license is something where you continue to own your IP and you just let somebody else use it. An assignment is something where you actually give the other party ownership of the IP. Joint venture is pretty straightforward. Development is basically I'm creating some IP on behalf of another party and they're going to own it. And then the rest of them are all pretty straightforward as well. Each one of these types of transactions will present slightly different issues, which Kenny will go over in a little bit more detail during his. So there are a few different types of substantive law that work in licensing agreements in the U.S. So there might be different types of intellectual property law depending on where your company is based and or planning on doing business. So U.S. intellectual property law obviously applies in the U.S., but if you are a European-based company, EU intellectual property law might apply, and the different types of subject matter for intellectual property might differ between those areas, and it might differ on a country-by-country basis as well. So in the EU, for example, databases are protectable as intellectual property. In the U.S., they're not. In the EU, you actually have to register trademarks in order to have rights in them. In the US, that's not necessarily true. You can get common law rights in a mark just by using it in commerce. So there are a lot of little nuances. Generally, it's pretty straightforward. The Uniform Commercial Code is basically just the kind of general principles of contract law that apply. In every country throughout the world, there's something like that, but because we have 50 different states, we have 50 different types of state law that could apply to action. So the Uniform Commercial Code is kind of, this general commercial body's attempt to bring uniformity to that. So there are also privacy and e-commerce laws. COP is is basically a law that's designed to, I think it's the Children's Privacy Protection Act. Basically, it's trying to prevent people from getting data from kids who are under 13 who might not otherwise know that they're giving up data. The DMCA is the Digital Millennium Copyright Act. It basically provides certain safe harbors for service providers who have user content uploaded on their system. So for example, when you're on Facebook and or something like that on Facebook, The DMCA is what allows them to not get sued if that defames somebody else, or if it, infringes somebody's copyrights or something like that. Antitrust and bankruptcy are just kind of general background rules. You can't act in an anti-competitive way, and bankruptcy just regards how you kind of basically how you kind of deal with things when the company dissolves. So, in the U.S., there are four basic types of intellectual property law. There's patents, copyrights, trade secrets, and trademarks, and they all differ in fundamental ways. So, patents. In the U.S., it's governed by federal law, not by state law, and there's only one federal court that really deals specifically with patent law, and that's the Federal Circuit. And they are more or less the last word on the interpretation of patent law. In the U.S., patents protect certain subject matter, and it's an idea or invention for a process, machine, or a composition of matter. Rights arise through patents granted by the USPTO, so it's not just something that naturally arises from you creating something. It's something that you actually have to file, register, and get through the patent office and have granted in order for you to have patent rights. And again, there are also non-US patent offices that you want to be aware of if you have certain technology to protect in other areas. So rights generally last 20 years from the application date. The date application to the actual granting of the patent right can differ depending on certain circumstances, like what the technology is that you're trying to apply for, how big the backlog is at the PTO, and certain technologies or other laws that might apply. So, for example, if you're dealing with biopharma or something like that, or pharmaceuticals, generally the time from application to grant is significantly longer because they need to go through a much more kind of robust process in order to validate the patent. So when we're talking about patent rights, or really any registrable intellectual property rights in the US, there are certain exclusive rights that you have. It's not just a kind of, I have the patent, so I have the right to do anything that I want with it. You only get certain exclusive rights granted by statute. So in the US, those rights are the right to make, use, sell, offer to sell, and import the patented product. So with respect to level of exclusivity, patent is what we would call a strict liability system. So you have complete exclusivity even as the independent development. If there are two people that come up with the same idea at the same time and they try to patent it, essentially the first person to file the patent in the US is going to be the one who gets the right to use it exclusively, regardless of all of the time that the other guy put into it. Which is a pretty strict standard. And what that also means is that on the back end, when there's a potential patent infringement or something like that, it basically means that, regardless of whether or not, the second party knew of the first party's patent, were implementing their technology or using it or something like that, they could still be held to be a patent infringer regardless of that knowledge. So some of the issues with patents are that they are expensive to develop, maintain. So in terms of actually getting a patent, there are significant application fees, maintenance fees. In terms of actually getting the patent through the patent office, oftentimes there will be significant negotiation between you and the patent agent, and you'll generally go through and negotiate like multiple different drafts of your patent application just to get it through. And litigation can often be hard too, because a lot of whether infringement exists will depend entirely on what a judge thinks your patent application means, which requires really detailed parsing of each individual word of the patent application. So, copyrights, which is something that most people in here would probably be a little bit more familiar with. So again, in the U.S., this is a creature of federal law. The 1976 U.S. Copyright Act is what applies, and it creates certain standards for what constitutes a copyright, whether and to what extent you have to register copyrights to have any rights there, and that type of thing. So copyrights are easy and free to procure. Anything that I write down that is an original work of authorship fixed in a tangible medium of expression is automatically copyrightable. So for example, again, if I am, just writing up a post, something like that, that is de facto copyrightable and is my copyrighted expression. even though you would think it's kind of, it's just, oh, he's just bashing off like 10 words on something. It's still copyrightable, and you could theoretically sue somebody for copyright infringement if they copied it in full after seeing it. So copyrights, because they have a kind of more limited area of exclusivity, last for significantly longer than patents. So it's typically 70 years for a natural person, which is basically you or me creating any copyrighted work, or 95 years for a corporate author. Corporate author is basically like, internal creation of, documentation around software development or something like that. Practically, this means that it's almost forever in terms of the actual commercial value of the copyright. And pretty much on I think it's roughly 10 to 15 year schedule, in the US at least, various interest groups come in and they push for extensions of copyright law. And they tend to get them, which is why it's all the way up to 70 years plus right now. So what are the exclusive rights? So the exclusive rights that you have in a copyright are the rights to reproduce, distribute, publicly display, publicly perform, and prepare derivative works of the copyrighted work. Derivative works is a kind of tricky concept. It's basically anything that's based upon the original work. And, it can be a translation, a transformation, or an adaptation. So, for example, a derivative work of a book might be, a screenplay that I make of it and turn into a movie. So again, level of exclusivity, it only prevents reproduction, not independent development. So if we have two people coming up with literally the exact same expression at the exact same time, if this guy didn't know of this guy's stuff, he's not in stuff, and vice versa. So again, free to procure, difficult. So copyrights apply to a particular work, so they're often assigned rather than licensed, just because the scope of exclusivity is relatively low. Works, so a thing that might apply to you guys as software developers, performed on a work made for hire basis, copyright automatically vests in the employer. So if I work for Google and I, create I create, 100 lines of code or something like that, my employment agreement will generally say anything that I create during the course of my employment is going to be a work made for hire for Google. So unless otherwise agreed, vests in the employer if the employee creates work in the course of his duties. Generally, this doesn't apply for employers, so written agreements are required in order to actually assign the rights to the employer. And, here are your four things that you look at, especially commission. Yep, sure. Yeah, so it depends on an employee or a contract. Where you're doing the work, it also depends on what you're using to do the work. So if you're working at Google or Facebook or something like that, and you're actually doing all of the work on your, Google or Facebook provided computer on company time, then it might be more likely than not that it would actually be assigned to Google or Facebook, or whoever your employer is. If it's off of your company time and you're using your own stuff, regardless of what your employer or your employment agreement or contractor agreement says, if you're in California, like you would still own the rights to that because California has a specific statute on point. Yeah, usually the employment agreement that you sign with the company will say that all of that stuff is assigned to them. So regardless of whether or not they say, here's what you're hired for, you're doing this work, it's separate, they will generally have a thing in the agreement that says anything that you create during the course of your employment using our stuff is going to be ours. So one reason to kind of do that stuff on your off time if possible. Cool. Any other questions right now? Or moving on? No? Cool. Trade secrets. Trade secrets are something that seem pretty intuitive, but are something that most of you probably haven't actually done before. So unlike copyright and patent, trade secrets are governed by state law. So there's a general act called the Uniform Trade Secrets Act, which a lot of states have implemented, although they differ in kind of slightly different ways, and different states have different interpretations of the provisions of the Uniform Trade Secret Act. So realistically, it's kind of hard to tell before. Um, so what's protected? Secret ideas that are economically valuable. So for example, like the recipe for Coca-Cola is a pretty prime example of a trade secret. It's something that's not necessarily copyrightable. It's not by patent, but it's something that Coca-Cola keeps very secret and uses, tons of money and efforts to keep secret, and it is obviously economically valuable. So, sure. Yeah, so you're fine. So, like copyrights, independent development is a defense. Trade secret law only prevents misappropriation. So, if you were to go into Coca-Cola's vault and like steal their recipe and then try to use it, that would be prevented by trade secret law. But if you just created it on your own, you're totally fine. Mhm. I mean, so it would completely depend on, a ton of different facts. So, for example, how you came into the recipe for Coca-Cola. If you actually went in to the vault and like stole the recipe, and then Coca-Cola would still likely argue that you misappropriated their trade secret and used it as the basis for your new formula. Okay. So typically, rights and trade secrets last as long as the trade secret exists. So as long as it doesn't become public, it lasts forever. And if somebody else comes along and develops their own Coca-Cola recipe that is literally exactly the same as the Coca-Cola recipe and decides to make that publicly available, that's totally fine too. That recipe is not going to be available or available to be protected as a trade secret. So the exclusive rights are a little bit different under trade secret law. It's generally only to practice, use, or disclose any kind of idea or information. Typically, trade secrets are the types of things that you would see covered by a confidentiality or a non-disclosure agreement rather than. So again, as we discussed, only prevents misappropriation, which is basically, try to steal the trade secret, rather than independent development. So trademarks and service marks, like the Coca-Cola logo or the little Coca-Cola script. Marks in the U.S. are protected by both federal and state law. Typically, the federal law is the one that you care about, just because it lays out the clearest standards. And by filing a trademark with the U.S. Patent and Trademark Office, you actually give everybody else in the U.S. constructive have the rights in the trademark. So they're basically assumed to know about your trademark. So anything that designates the source of origin of goods or services. And as interpreted by the USPTO and various courts, that means literally, it could be like a drawing or a logo, could be the name of a product, could be the smell. Essentially anything that serves a source identifying function could be protected as a trademark, at least theoretically. But rights arise automatically upon use or filing of an intent to use application with the Federal Trademark Office. You generally office just because it provides you certain benefits that not registering does not provide you with. So that'll be statutory damages, which are generally quite a bit higher than if you were to just go out and sue somebody, because then you would only get actual damages, which are generally significantly less than what statutory damages would be. It's also prima facie evidence of ownership of the trademark itself. So, again, as with trade secrets, rights last as long as the mark is continuously used in commerce. But if you abandon your mark, then those rights effectively go back into the public domain, and somebody else can pick up that mark and use it on whatever services. The exclusive rights are use in connection with offering goods or services. Talking about a registered trademark, generally what you will do is you will actually define your goods or services, and you will, in the application for the trademark, and you will actually choose a specific class of goods or services, right? So, Facebook, their trademark application likely says something along the lines of, this is a trademark for use in connection with a social media networking service and software related thereto. And basically, there's a little bit of kind of, an aura around it. So, for example, the registration may not protect just that specific thing, but anything that's also likely to confuse consumers with that thing. So, if somebody else uses Facebook for, I don't know, banking software or something like that, Facebook would still argue, hey, that's substantially similar to, or that is likely to confuse our consumers as to the source of those goods, so they can't use it. So again, complete exclusivity in that specific class in preventing others from confusing uses, and you have also this little area around the right that you're also protected against. So one item can involve all four types of IP. So coming back to our Coca-Cola example, there's the picture of the Coca-Cola bear. Trade secrets, again, the Coke formula is a classic example of a trade secret. Patents cover the the shape of the bottle and venting devices and bottle composition. Trademarks cover the script Coca-Cola, as well as possibly the Coca-Cola bear for use in connection with Coca-Cola products. And probably more relevant to you guys, software can be covered by all four types of these rights as well. So the code is a copyrightable work of authorship. Trade secrets might protect certain aspects of the source code. Patents might cover particular inventions implemented by the source code, and trademarks may cover the brand name or the product name that you use in connection with the goods or services. Sorry, say that again? Literally simultaneous so it would literally depend on who got there 1 second before the other one. At least right now in the US. And that's how it works in most other countries as well. It's a first to file system. Yeah. I mean, hard to say what they would do with that. Yeah, there is. It's more or less a sorry. It's still more or less a theoretical problem though, because yeah, I mean, it's the likelihood that you're actually going to try to patent the exact is very low. It would likely be a contract claim that they would have against him, and they would also claim that he misappropriated their trade secrets. They would have to prove that, yeah. However, if the guy was literally employed at the place on day one, and then on day two he goes and files a patent application for something that he was working on during the course of his employment, not likely to be super hard. Any other questions? Mm-hmm. What do you mean? Generally not. What you would probably want to do is you would want to have your patent prosecutor draft it a little bit more broadly than that. So, like, a case for mobile devices that, attaches via like a magnetic strip on the edge of the thing or something like that. The broader the better, usually with patents. Anything else? No? I'm going to turn it over to Kenny then.
All right, can everyone hear me? All right. Thanks, Tim, for providing the overview of uh, IP rights, which will be helpful as I will be discussing ways that you can actually commercialize these rights. So the two ways that you generally can commercialize IP is either through a license grant or the buying and selling of your IP. And so license grants, as Tim showed in his first slide, can come in a number of sort of variants. What we typically see in your day-to-day life, if you download any software, you'll get a click-through license for you to use the software. Alternatively, every time you download a song online, if it's through iTunes or a similar legal application, you get a license to use that song, which typically terminates when you die. But so those are examples of how you can commercialize your IP by granting less than entire rights. So a license grant is granting certain rights to use or reproduce or certain other rights for IP, whereas I put up here mergers and acquisition transactions because that's the typical way that IP is bought and sold in a lot of commercial transactions. And that divests you of your entire right to that IP. So I'll go through these in a little more detail. So what is a license? As I said before, it's a grant of certain rights with respect to some or all of the IP rights. So for instance, when you download a song on iTunes, you get the right to listen to it, you get the right to copy it for your own personal devices, but it doesn't give you the right to resell that song to any other people. As I said before, it's not an assignment or sale of the IP rights. The underlying ownership rights always belong to the licensor or the owner of the IP. And a technology agreement may include a license of certain rights, but the parties may also assign certain rights. So you can have an agreement that both assigns IP and licenses certain IP, and oftentimes you can have complicated transactions where someone will assign IP and then grant a license back so they can continue to use this. And so oftentimes you'll see these in joint development agreements where the parties agree that one party will own all IP that's developed, but then the party that owns the IP will grant a license back so the other party can continue to use that in their business. And so going through the rights that you can license in the types of IP that Tim spoke about before, for patents, you can license the right to make, use, sell, offer to sell, and import. For copyright, you can license the right to reproduce, distribute, publicly display, publicly perform, and prepare derivative works. For trade secrets, you can license the right to use and disclose, and then for trademarks, you can license the right to use it to in commerce to identify the source. So all IP rights need to be licensed, and this is very important when you commercialize IP because you can actually carve out the rights that you're willing to grant. So for instance, for patents, you can grant someone the right to make, use, and import, but not sell or offer to sell. So oftentimes this happens in manufacturing agreements where you license patent rights to the manufacturer so that they can make your product for you, but you're not granting them the right to sell the product. You want to control the actual distribution of the product. Similarly, in copyright, you can license the right to copy and modify the work, as is often done in software agreements, where you get the license to use a software and copy and maybe make some changes to the software, but then you can't distribute it, so you can't go off and resell the software. You can't publicly display it or publicly perform it. So that means the license is only for your internal use. And so one thing to keep in mind that because you don't have to grant all the rights, how you draft the license that you're giving is infinitely important for both your retention of rights and your licensee's use of the IP that you're granting. So for instance, for the geographic scope, you can either grant a worldwide license. So if you grant a worldwide software license, the licensee can use the software anywhere in the world, whereas if you grant the license limited to a specific building, then they cannot take that software and use it even across the street. Similarly, exclusive and non-exclusive, if you grant an exclusive license, sometimes you may not even be able to use your own IP anymore. So this is an incredibly important character of the license grant. Generally, if you want to continue to exercise your rights under your IP, you want to grant non-exclusive rights. Similarly, the payment, how you're getting paid for licensing the IP, which is an important consideration when you're trying to commercialize your IP. Oftentimes we'll see that you'll get paid in royalties or upfront license fees. But this is transaction dependent, and so really depends on the situation. Another important consideration is how long of a period the license should last. Sometimes the licensee will ask for a perpetual license, which essentially gives them the right to use forever. But oftentimes you'll see limited license grants, for instance, 2 years. If you download, for instance, if you download Adobe Creative Cloud right now, it's a subscription, so you have an annual license, and at the end it terminates, and your rights to that software terminate with that license. And there are some other more specific restrictions that you can place. You can limit the use to specific equipment. For instance, if you license software out, you can limit that use to the hardware that you provide in conjunction with that software license. Or you can limit it to this software can only be used on iPads, something like that. You can also limit the scope of the license, so solely for the purposes of your evaluation, which is important when you're only granting a trial license, as opposed to a commercial license where the licensee can use that in their business. And then an important right is the right to sublicense. If you want to maintain control of your IP, you generally don't want to grant your licensee the right to sublicense, as then their use of the IP can spiral, and you generally lose the right to control who can use your IP. And similarly to the chart before, you have all these rights that you can decide whether you want to license out, and you can chop them up as you feel. So, for instance, under patents, you might grant the licensee all of the rights to make, use, sell, offer to sell, and import, but you might limit license for selling to certain time periods, or you might limit the license to use to a specific field. Similarly for copyright. So the main elements of a license, I put this up here just for so you know, generally when you start commercializing your IP, people will ask for license agreements, and this is generally what it contains. The most important parts, I think, for you would be technology, because you want this to be as narrow as possible, rights to IP you don't want to be granting rights to. So for instance, if you're licensing out software, you generally want to refer to the software in question and the version number so that it doesn't include all future versions. You want to control how you release updates. The grant clause, as I described before, you want to generally tailor the scope of the grant to what you actually want to grant. So whether it's perpetual, non-exclusive, things like that. Ownership, one thing to definitely include is you want to make a claim that except for the rights that you're expressly granting to the licensee, you retain all other rights. So that way, no confusion as to who owns your IP. It's you, and you're only granting these limited rights. Fees and royalties. We're discussing how to commercialize your IP. This is very important. And generally, this is where a lot of the negotiation happens, is how much you get paid. And the rest is generally more legal in nature, but deals with how much ability you have with respect to your product. So I think I discussed this a bit. So there's generally no standard license terms. They are typically tailored to the product that you are licensing out. That being said, a lot of products are very similar. So you'll have pretty standard software license terms that you can generally borrow and use for your product if you can find a comparable product. As I said before, the grant clause is one of the most important, most negotiated areas, because this discusses what rights you're giving away and what rights you're keeping. The next 2 points deal with if there's a license grant or any development work in more of a services context. So for instance, if you're providing services to your customer and you're developing IP, the customer typically wants to own any IP that's developed. And one here is whether you're developing this IP for that customer solely and you don't want any rights in that anymore, or if you want to use that IP that you develop for future customers. In case you would want to retain ownership and just grant a license to them. And then one thing to consider, yep. Right. Okay. Right. Right. Exactly. Right. So they develop it. They gave the IP to the Japanese calculator company, or they kept the IP, but gave the Japanese calculator company, right, a license so they could continue to use it. And so one consideration when just determining whether you want to continue owning the IP or whether you are comfortable with assigning it is looking at the form and how that IP was developed. So for newly developed IP, it can either be developed by you, it can be developed by a third party on your behalf, or it can be jointly developed. And so this may impact your consideration for who owns that IP, but ultimately the decision should come down to whether you think this IP will be beneficial in your business in the future. You can always negotiate these rights. And so if you think you need the rights to continue using it, perhaps you should own that IP and grant them a license. With respect to pre-existing IP, there should always be a carve-out. When you enter into an agreement, you never really want to assign away your ownership rights in pre-existing IP. If you perform any services or for a party or for the other party and you use your pre-existing IP, you want to make clear that that's just a license for the purposes of performances, and you're not assigning your rights away. Otherwise, that restricts your ability to do business and utilize your your pre-existing IP. So that was a general overview of licenses, which is a fairly common way of how you commercialize your IP. The other common way that we often see commercialization of IP is through the buying and selling of IP, and the most common way is through M&A transactions. So what are M&A transactions? Dealing with the buying and selling, dividing and combining of different entities. So these are typically through stock purchase agreements, asset purchase agreements, or mergers. So for instance, if Coca-Cola bought Pepsi and they became one company, that would be a merger. And so the new company would own the IP from both Coca-Cola and Pepsi. And one common thing we're seeing in this area recently is the difference between buy versus build. So historically, companies would build their own IP from scratch. They would have their employees in their research and development departments create the IP. Nowadays, you're seeing companies like Google, Facebook, Amazon, companies like that find small startups that are developing interesting technology, and instead of having their own build those, they're just buying those companies and incorporating them into their overall structure. So for instance, Google purchased Nest for $3.2 billion. So instead of creating their own home temperature systems, they technology and will be incorporating them into their products. Apple also purchased Siri, which they use on their iPhones and iPads. And Facebook recently purchased Oculus Rift, or Oculus, which is virtual reality technology, for $2 billion. So this is a common feature and is something to look out for as burgeoning entrepreneurs in the startup community. This is one way to really commercialize your IP. Once you get a viable product, you will probably have companies like this knocking on your door. And that's what a lot of people think is a good way to capitalize on what they've developed. So the role of IP in M&A transactions is now becoming very important, and there's a lot of scrutiny because oftentimes for smaller companies, the IP most of where the value is. I've been working on a transaction recently where there are zero assets in the company except for their algorithm. And that's the only thing the company owns, and it's being valued at $18 million. So a bit of code is all it really takes to have people get interested in you. And so why this matters is if you ever get into the situation where you're getting interest from larger companies who want to acquire your company, they'll often take a close look at your IP. So what IP is owned by you, what IP you're licensing out to others, or what IP you're licensing in, how you're using your IP, maintaining it, protecting it, to make sure that you have valid rights and that the way that you're using it is not violating other parties' rights, and that once they acquire you, they will continue to have the same rights in your IP. And they'll also take a close look at the policies that you have regarding the creation and use of IP. As Tim discussed earlier, and I think there was a question about this, it's very important how you deal with IP that's developed by your employees and consultants, as you want to make sure that you own all of that, as buyers will assume that you own it and will want to see documentation to that effect. And so one thing to keep in mind, because of the increase in interest in mergers and acquisitions, is proper IP management. Oftentimes, smaller companies are reactive when they deal with IP or intellectual property management. So they'll go through the entire phase of product concept and development and then only deal with how they manage their IP. So then they'll start looking at whether they actually own their IP, whether they have all of the agreements in place to show that they have all the rights to use it as they are currently doing. But if you are seriously considering getting purchased by a larger company, really think about IP management from the very beginning. So even before you come up with the concept of your product. And so issues for the founding team with respect to IP is whether there are any conflicts with rights with your former employers, whether you have the rights to assign the rights to the IP to the company, if there are any contributors, and if there are any third-party rights. So one major concern when you're starting your own company is whether you have the rights to put that IP in your company. And oftentimes we'll see founders of their company bringing in technology that they learned or either acquired from their former employers. And so one thing you should do is take a look at your agreements with your former employers to make sure that you have the rights to take the IP that you're investing into your new company. In addition, if you don't have the rights, you shouldn't take proprietary materials. Otherwise, your former employer can make a claim that your entire business is based upon their property, and so they can sue you for infringement or claim that that property is now theirs, which can seriously devalue the IP in your company. And as Tim spoke about earlier, there are certain laws, and it depends on the jurisdiction, but if you, at least in California, if you use company resources or time in developing any IP, then that is generally deemed to be your employer's IP. So even if you think that, even if you're coding at home on your own time, but you're using a laptop, that can still be considered your employer's IP. And so if you take that to your new company, you might not actually have the rights to that. In addition, going to the last item, if you leave your former employer's employment on good terms, that's better, as you might not actually have all the rights. But I've been working on an issue lately where an employee didn't necessarily have the rights to use certain IP in his own business, but was on great terms with his former employer. The former employer agreed to just assign all the rights that he or might have in that. So if you leave on good terms, there's always a possibility that you can come to an agreement on the assignment or licensing of IP that you need to continue to run your business. So the initial assignment of IP into your business, generally the way that this is done is you assign your rights in your IP to the company for your shares in the company, and then there'll be an agreement put in place so that anything that you develop from that moment on is the company's, and that way the IP always lives in the company whether you stay or not. But one thing to keep in mind is that you cannot give what you don't have. So that's another reason why the previous slide was so important, is because if you don't actually have the rights in that IP, even if you have an agreement that says you are assigning your rights in that IP, if you don't have those rights, the company really has nothing. Another thing to consider as a starting company is putting in place the necessary agreements for your employees and contractors to make sure that everything that they develop in the scope of their employment or engagement with the company is owned by the company. In addition, in the US, there, as Tim spoke about with respect to copyright, there's such a thing as work for hire, which does require certain language, just the work for hire language. But if you include that in your agreements with your consultants, then anything they create in the scope of their engagement is automatically owned by the company and doesn't need an assignment. In addition, another thing to make sure you have with respect to consultants, as they may bring in pre-existing work, is that you get a perpetual license to anything that they incorporate into your products. Otherwise, if the consultant leaves, they may input certain material IP into your products, and you will no longer have a right to do that, and you'll have to redo the product from scratch. I don't know if you want to discuss open source. Another thing to consider, especially on the software front, is the use of open source software. A lot of times, this is an incredibly useful application for your company because it's free, and it saves you a lot of time. That being said, there are many licenses out there, such as the GPL, CDDL, Mozilla Public License, which contain provisions that are commercially unfriendly, such that if you use them in your code and you want to distribute or commercialize that code, they have requirements in there that you have to distribute your source code, which essentially renders your entire software program commercially unviable. So one thing to keep in mind is it's open source in your products, but you need to look at which licenses they're being licensed under to make sure that you're not incorporating any code could potentially render the software that you've put all of this time and money into commercially unviable. And so that's it. Any questions? Mhm. Right. Same thing. So it's on the company's premises. So even if it's your own personal property, under California law, it would be owned by the company. So if you really want to make sure that the things that you're developing are yours, they should be off company premises, not using anything of the company's. Uh, so generally code at home on your personal laptop, or even if you code at a coffee shop, things like that.
that
No.
probably would not happen
Yeah.
here.
So, so the employer could probably make a claim under contract as well as copyright law. So it's very unlikely that would happen. It really will depend on the agreements that the employer has with the employer or consultant. In addition, what documentation to show that he was hired by them to create that code. And I would assume that there are logs showing that he developed that code and gave it to them before he went off and tried to get protection on his own. Oh,
Yeah.
right.
Yeah, so I mean that's what Kenny means by the contract will that matters most. So the contract lawyers at the Russian company probably should have had something that said anything that you do on company time or with company resources is going to be assigned by us, no matter what it relates to. As as opposed to saying like you're going to be working on X project and anything related to X project that you create is going to be owned by us.
Oh, right. That's a that's a common thing that people used to do for copyrights. Yeah, it's the same thing. You can send yourself an email, and that's putting it in a tangible medium. So then that also has a timestamp, so you know when you created it. So it's documentation of the time you created it and the fact that you have created it. Mm.
In the U.S., it doesn't matter anymore. It's a first to file system.
Right. Well, so that's for patents. With
Yeah.
respect to copyright, because you can independently develop it, and you will both have copyrights in it.
Yeah. Copyright protects only expression, not ideas.
Right.
Patents are for ideas.
S- so again, I think that will probably depend, at least in the U.S., on the agreement that you have with the employer. If the agreement you had with the employer was as broadly drafted as we typically have them here, they would own everything, including unprotectable IP. So this is any know-how, research, things like that. They would also claim they have ownership. In addition, there are often confidentiality obligations in your agreements with your employer. So how we usually draft them is once you leave the employment of your employer, you typically can't discuss anything that you worked on during that employment. So that's likely why they were upset, at least. Oh, okay. Yeah, I mean, again, it would really depend on what was in the agreement, and I mean, even if they had no rights to make that claim, uh, companies still oftentimes will make a claim just because they're in a position of power there, and so if they're dealing with an individual, they can make unfounded claims and often still get something that they want. Yeah, thanks. No problem. Our emails are up there, so if you have any additional questions, feel free to let us know. Yeah. So we have a forms database online where we can direct people. I think they contain
Just like initial incorporation documents,
Yeah.
Confidentiality, invention assignment stuff.
Right. So agreements you would want for your employees, things like that, we can provide for free. Yeah.
Sometimes the firm. Oops, sorry.
So it really depends on each situation. Generally, we like to have all the rights spelled out before the research even begins. Um, but if you have no idea what the fruits of the research will be, you can include language that says the parties will agree to who owns what later on. But that leaves open to dispute in the future whether the rights granted are actually sufficient. Which is why we always prefer to see the rights laid out in research is done. So typically, the entity that hires them to develop it will want to own it, and more often than not, that's the. But if you're being contracted just to provide those narrow services, you might be able to make the argument that you're performing these services, and similar to the Intel Japanese calculator example, you'll at a lower price to retain your IP.
It depends on the treaties between the countries. So, right, so like the Berne Convention on IP applies to most countries right now. Most countries have agreed to it. There are also other treaties currently in negotiation. Yeah, I mean, like during the early days of the United States, I mean, there was no like IP agreement or treaty between the U.S. and England. So basically, what U.S. entrepreneurs did is they essentially copied books and stuff wholesale from Britain and just distributed them out here. Yeah, and they made a lot of money.
Yep.
Cool. Thanks, guys.
Thanks, everyone.